果大家見到下邊嘅地球儀，麻煩你點擊一下選擇中文，咁你就會進入到中文頻道。如果你係用手機嘅咧，麻煩你點擊上邊嘅3點，就可以進入到翻譯頻道噶啦。多謝。
Okay, so can someone just tell me, I want to make sure that worked for the interpretation for our Chinese speakers?
She's on mute right now.
I did not hear it on our channel.
Yeah,
but we're doing the introductions in the different languages before they go into the interpretation channels.
So you go with Chinese first. She should go first because she was mute.
Right. You know what? I think someone needs to help Susan with her
I can go with Vietnamese. Xin chào quý vị, tên tôi là Linh, tôi là người phiên dịch của quý vị. Một khi chúng tôi đã kích hoạt tiếng phiên dịch cho thì quý vị bấm vào cái biểu tượng quả địa cầu và sau đó quý vị bấm Vietnamese là tiếng Việt để được nghe trực tiếp phiên dịch bằng tiếng Việt. Nếu mà quý vị dùng điện thoại thông minh, xin bấm vào 3 dấu chấm rồi sau đó chọn phiên dịch Language Interpretation và sau đó quý vị bấm vào tiếng Vietnamese và sau đó là done. Quý vị sẽ được nghe phiên dịch trực tiếp. Xin cảm ơn quý vị. Thank you. I'm passing on to Portuguese interpreter.
Portuguese, thank you.
Hi, Sarah. Can you introduce yourself, please? I'm not hearing her in English or in the channel. Chetna, do you know if the interpretation is turned on?
Yes, it is. I heard all of them.
Okay. What I think is happening, so for those of you, forgive us for a little glitch right now. I think those of you who pressed on the globe and selected your language you were able to hear the correct language. And if anyone is having trouble, if you could just let us know in the chat, please. And I do hear that someone can't hear Sarah in the Spanish room. So I'm wondering, Renee or Chetna. Okay, it's all set now. Okay, well, thank you, everyone. And again, I apologize we actually practiced this and it worked well in our practice. But again, I'm so happy that you all joined us tonight. My name is Pam Nurse, and I am the Executive Director of the Federation for Children with Special Needs. Tonight's event is a follow-up to a previous webinar. And during that, we heard a real desire for more information about compensatory services and as well a continued concern from parents about their child's lack of progress in schools. And we have a wonderful panel that has come together, and I really thank all of you for joining us tonight to be able to talk more about compensatory services and related topics. And I know we have a lot that we're going to cover tonight, so I want to jump right into it. We are recording the webinar and we will make it available after the event. I'd like to ask you to please use the Q&A feature for questions. We will get to as many of them as possible, but our experience has been is that we're not able to get to all of them. And we will be reviewing all the questions that you put in the Q&A, and we're going to use them to guide what information we'll put out on our website, our Facebook, our emails. And I want to encourage you, if you have a specific question that we're not able to get to tonight, to please contact our information center. We'll put our phone number, our link to our website, so that we'll then be able to get back to you and help you. At this point, I'm going to turn the program over to the Federation's MassPAC Director, Leslie, who's going to introduce our wonderful panelists and will be moderating tonight. So Leslie, it's all yours.
Thanks very much, Pam, and welcome everyone. We're really excited tonight to welcome back our panelists from the last session and welcome someone new. So tonight joining us is attorney Tim Sindelar, who's in private practice here in Massachusetts. Also attorney JANINE Solomon, who's with Mass Advocates for Children. And I'd like to also welcome Carol SILVA, who is an advocate practicing in Massachusetts, to add that voice to the table. So Tim, I believe you can share your screen now, your presentation, and we'll get started. Thank you.
Thank you, Leslie. I'm very pleased to be here tonight. And are people seeing my screen, hopefully? Nope.
Not yet.
Let's try this again. Nope. Works so well during practice, it's amazing.
There you go.
There we go. Okay, so what we hope to do tonight is to kind of dig in a little bit deeper in terms of practical things that you can be doing. We're really concerned that very little has actually been accomplished in Massachusetts.
Excuse me, Tim, can I just interrupt for a second? We're getting a request from the interpreters to for all of us to slow down.
Slow down. Thanks. We'll try and do that. I'm going to need reminders, so please don't hesitate to tell me that periodically from time to time. So, as I was saying, we're concerned that there have been there's been a tremendous lack of claims being adjudicated or being brought forward or being dealt with in an appropriate fashion with regard to the losses that our students have suffered during, first the end of the 2019-2020 school year and then last school year. And we want to focus on those two periods of time, not so much on this school year, although there may be claims for compensatory services that are accumulating during this time, but we really want to look at the claims that related to either the schools being closed, schools being in a hybrid fashion, services not being adequately delivered over the past. And one of the reasons we want to do that is that we're approaching a deadline that needs to be looked at in terms of these claims being able to be brought forward. In general, in special education law, there is a 2-year statute of limitations, which means that if you want to bring a claim forward, you have to start it within 2 years of when the claim arose. So if we're talking about the failure to deliver services during the time that the schools were closed, we're looking back to March of 2020 when schools closed for 10 days, and then some barely opened, some didn't open. There was a variety of things that happened. And then, of course, going forward the next school year, we continue to have problems. But this means that it would be very important to get these claims going by next March. Now, that doesn't mean that it cuts off all claims. Now, if you don't get something going by March of 2022, it simply means that you're cutting off anything that you don't bring before then, looking back with a 2-year window. So if you filed a claim for compensatory services in July of 2022, you'd only be able to get some compensatory services that relate to the school district's failure from July of 2020. So we don't want to lose those first months because they're probably the richest in terms of the lack of services. And so it's important to be looking at trying to move this forward. Now, the statute of limitations doesn't mean that you have to complete these claims within 2 years, but the process needs to begin to get the statute of limitations told going forward. Now, hearings at the Bureau of Special Education are just one way to pursue these claims. There are several other ways that it can be looked at. We're going to talk today about bringing complaints to PRS, a program at the State Department of Elementary and Secondary Education. The PRS has even a shorter time period that they want to look back, and they want to look back only 12 months. So claims related to the spring of 2020 are effectively gone if you wanted to do it through the PRS process. In addition, some of you may have brought complaints to the Office of Civil Rights of the United States Department of Education before. It's another way to pursue claims with regard to the obligation of the states of school districts to meet the federal law of IDEA and the protections of Section 504 and the ADA. But OCR has a very tight time frame. They want to only deal with matters that are filed with them within 180 days. So there are those considerations, and this is a reason to move forward. The Council of Parents, Attorneys, and Advocates, a national organization of those parties, recently completed a survey of people nationwide with regard to compensatory claims. And they have reported just out this morning that fewer than 1 in 5, less than 20% of parents reporting on this survey reported that they had been offered anything in terms of compensatory services. Not anything that was necessarily acceptable, but anything, which means that 80% of people haven't even gotten some of the preliminary process that they're probably entitled to under the law. So we want you to be able to move forward on those matters tonight, or based upon what we can provide in terms of information tonight. And then finally, there's a kind of a practical reason for moving forward now and not delaying. And that is that school districts have available to them through the American Recovery Act, a great amount of funding that they can spend in a variety of ways, but specifically that they can spend with regard to providing compensatory services. And this decisions are being made by local school districts and local school administrators about how they're going to allocate those funds as we speak. And we certainly want you to be in line and be part of that process so that these funds are properly allocated and get to students who have been denied services over the last 1.5 years or 2 years, rather than to software companies and slick vendors of books and things like that, that might be great, but aren't going to help your particular child with this particular need. So be prepared, take action. We hope that the messages that we give you tonight will help you move forward. Janine, you want to add anything to that diatribe?
Yes, I just was going to remind people as well that DESE has put out guidance. I believe it was right at the end of summer before the start of the school year, letting families know that if their teams have not met to discuss any COVID compensatory services, that the team should be reconvening now. So they certainly put out that information. And I just want to echo what you had said before too, that came from the CPCS study, is that that's what we've been hearing anecdotally through our helpline, is that families just have not been notified, really have not even understood that their child could get compensatory services. So that's why tonight's training hopefully will be very helpful for families so we can help to just break down about how to make those requests, what to do to build up the cases, because there's a lot of information, as you said, Tim, that's kind of rich that families probably have access to, and will help you all try to put that together so you can bring that to your teams.
Thank you. So we spent a lot of time back at the early September talking about general principles of compensatory. We reviewed in some detail an administrative guidance that the state Department of Elementary and Secondary Education issued in late August of 2020 with regard to the obligation of schools to provide COVID compensatory services. We're not going to do that tonight in such detail. Instead, we're going to try to drill down on what it is that you should bring to the table and be prepared to talk about in bringing forward these matters for your child. But it would be wrong if we didn't start from the basic proposition that no matter what you might be hearing from people at your school, people in general, nothing changed. You know, even though schools were shut by order of the governor for a short period of time, even though it's very difficult, it still remains very difficult to staff programs appropriately. Schools have the obligation of providing all the services that are on the IEPs. And so the failure to do that in the past gives rise to these claims for compensatory. Nothing changed. The state has said that over and over. The federal government has said that over and over. That's just as clear as can be. And anyone who tells you differently is just simply ignoring what the rules are. So with that as the background, how do you go about doing these things? We've given you tonight a pretty extensive set of resources, and we hope that you get a chance to look at them at some point going forward. But one of the first things I want to talk about is a sample request that the people at Mass Advocates for Children put together to request that decisions be made about COVID compensatory services. The slide contains that letter. It's also in a nicer form in your materials, but it's a simple letter, as you can see. It simply directs the school district, to have a meeting and to discuss COVID compensatory services. So if you have not had such a meeting yet, send this letter out tonight or tomorrow and get these in meetings going. Janine or Carol, anything you want to add to that pretty simple process to get this moving?
It's certainly also available on our website, but most definitely, and I think just the categories will help you to be able to kind of focus in a little bit more in terms of thinking through about what your child may need or some of the skills that may have been lost. And I agree with Tim, is that certainly time is of the essence if you haven't gotten it out, and this is a quick way to be able to do that.
The only thing I would add is I think if you don't know all the services that your child has missed, don't worry if you can't name them all. If you can just generalize it to get something in writing to the school that you're requesting a meeting to discuss this.
Mm-hmm.
That's right. And it's very important that you start with this process. If you rushed to go to PRS and said, but they haven't had a meeting, if you filed at the BSEA, it may be much more difficult to be able to prevail on your claim if you haven't tried to start the process. It's always important to try and generate and try and get these issues resolved on a local level as possible. So once you've done this and the school district comes back and says, okay, we want to have a meeting about compensatory services, what should you do? What should you be assembling? And so we've got a few slides here, and Carol's going to go into some detail about this too, but let me just kind of go through some things that you should consider. Certainly to the extent that you can, information about services that were missed. We're going to look at the service delivery grid on the IEP a little bit later to help you interpret that and help put that together. But certainly, there was a period of time when many students received no services. It should be relatively easy to take your IEP and look at it and say, all of these times my child did not get any of the services on the IEP, and use that to begin to format your claim. But You know, to the extent that you can, when there was hybrid services, we know that many of those services were ineffective. You need to look at those and count those times too. The other, one of the other main considerations is it's not just enough to say, you know, my child didn't get 10 sessions of speech as required by the IEP, but you want to be able to talk about what that meant. If you could see regression, and Carol's going to talk about this, you know, you want to be able to provide information about that, and about the effect, what you've seen in your own home, what you've seen going on. And, you know, as part of this, any information that you can provide from outside sources. If you've got outside therapists of any kind, if you have home ABA providers, your pediatrician, if you have a wraparound services, if you've had formal evaluations, all of that information is going to be very important in looking at the effect of these lost services. And you don't have to stop at just professionals that know about special education and come from a medical field or a therapy field. Other people, you know, athletic teams, coaches, you know, music teachers, babysitters, scout leaders, religious leaders. Other people may know about your child and have seen the effects of having lost services and might be able to provide information. Just a simple letter, a short email to the effect can be helpful in being able to present your case effectively to the local school district. What I've found is that you want this information to be as specific as possible. You know, it's one thing to say generally, you know, my son with autism spectrum disorder, you know, was in a fully remote period of time for 6 months and he got no benefit whatsoever. And while that's probably true, it's much better to be able to move beyond the generality of no benefit to specifics. And again, that's why these collateral sources are important, or your own information and your own observations are important. There was this case at the Bureau of Special Education Appeals in which essentially the family was saying that you know, our child could not benefit at all from remote instruction. And, you know, unfortunately, the hearing officer said, well, you know, that's too general. I don't know. I mean, I need more information. And I think if they could have just provided a little bit more detail about their own practical observations or a little bit more outside information, they may have been more successful with regard to these claims. That should be so obvious to all of us. It seems like it's just common sense, but you have to understand that, you know, the appeals process that we go through isn't really based so much on common sense. And so it's really important to be specific, have good detailed information. You know, the slide says it should be in writing where it's possible. You know, that's something you're going to hear from attorneys over and over again. If it's not in writing, it didn't happen. It's just, again, it is it's a way of making your case, and you have to start that with these team meetings or other meetings with administrators around this. And then finally, the last point that I have on this slide is to bring help to meetings. I feel that this is a kind of a cardinal rule I put out in general to the parents. It's always much better when there's somebody there to help you. And there's a lot of reasons for bringing someone to the meeting. I mean, you as a parent are going to be emotionally involved. It may be kind of overwhelming emotionally to bring forward all this information, to keep on track and to pay attention to what's being said and be able to respond to things during the meeting. It's helpful to have a helper there, you know, and that helper can be anyone. You know, you have a right under the law to bring anyone you want to a team meeting. So it can be your neighbor, it can be your mother, it can be your sister, it can be a religious leader, it can be the neighbor next door, or it can be a professional advocate or an attorney, you know, depending upon who you want to bring and what you and how that might go. So those are my recommendations about what to think about in terms of coming to this meeting. Janine, Carol?
I just wanted to also remind people, because in the meetings that I've been in, that a lot of the schools are relying on regression being the only standard, and it's not. So I think that that's important, where you're, and I agree with you, Tim, to have, if you can have somebody that can attend with you, because it can be very daunting to be around the table with a lot of people who are all saying, well, there's been no regression and everything is fine. This way, you'll have all this information that you've thought about, and as Tim said, some of it may be in writing, some of it may be stuff that you've actually been an eyewitness to, where you've seen your student and you can relay that information. But it's just, I think it's really critical. Carol?
No, I think that's all great information. I think the only thing that I would just emphasize is bringing someone with you, and it could be anyone, a friend, a sister, or brother. It's really hard when they're talking about your child to really focus on what they're saying and kind of remove the emotional piece of it. I know this as a parent, it's really difficult. So just having someone there that's going to take notes, that can just listen to what's being said so that you don't have to worry about that, is really valuable. And I agree, I think, and I'm going to talk about this a little bit more, about all these other people that are outside the school that can talk about your child and what they're like today, you know, pre and post pandemic.
Yeah, one of the things I've learned over the number of years I've done this is that bringing someone to a meeting often changes the tenor of the meeting in terms of how the team relates to parents. Sometimes, you know, school people aren't exactly the friendliest people in the world. Sometimes they're downright rude. Sometimes it's difficult to do that. But by having someone from the outside there to witness this thing, you know, so it's not just, you know, the parents' word against all these 8 or 9 people arrayed around the table. It becomes important. It changes the dynamic. So we couldn't stress that more. So let's move on to you know, some of the things that the team should actually consider. Now, obviously, they should consider all of those things that we're telling you to bring to the meeting. But this is information on this slide is taken from the state's guidance around the analysis that should be given. These are some directions from the state. So again, you'll see that there's some overlap here. You know, obviously the team has to consider the services that were provided, or the ones that were not provided, or the ones that could not be accessed. You know, and again, it could be a question of technology. I mean, the school could have provided a great remote system, but that the family did not have the technology one way or another to access it, or the ability to sit with a child who needed one-on-one attention to access it. So we look at those. Other barriers to access, there may be language barriers to accessing remote instruction that occurred during that period of time, beyond the technological things that we're talking about. Obviously, one of the most important things that should be looked at here is the level of academic and functional performance. And what does that mean? Well, how well is the student doing in general? And then translating that or transliterating that to the ability to access instruction remotely or in a hybrid fashion during the period of time that the schools were not fully open and not fully functioning. Any kind of data collection and progress monitoring that took place. This says over spring and summer, and it was based upon the state's directive, which was issued in August of 2020. You know, they did not anticipate that we would have the open close hybrid, you know, mess that we had last year, the chaos. So obviously the spring and summer could be ignored. It's any kind of data collection and progress monitoring. And I'll let Carol talk about progress and monitoring here in a couple of minutes. But, you know, the team should be hearing from teachers, service providers, provider agencies, and considering that information and observation of the parents, caregivers, and family members. And I'm going to stress, you know, we stressed that in the slide about what you should bring to the table. The state has acknowledged that the parents were in better control over the effect that the pandemic has had on their children than teachers then the school administrators, then evaluators. I mean, parents knew what was going on, and the state has emphasized that that information needs to be taken into consideration and given some priority status in making these determinations. And then the team may want to look at how there have been past episodes, perhaps when there were regression, and how long it may have taken the child to recover and to recoup. We often talk about this in terms of looking at whether a student should be provided services during the summer. We look to see, are there periods of time when, because of interruption of schooling, that they actually lose skills that they've acquired. So if there are past instances, obviously that's information that's valuable to the team in trying to determine how much compensatory services should be provided and what should be the nature of those compensatory services. Janine, thoughts?
I had a thought, it just went out of my head, but yeah, Carol, if you just go in first, I will, probably it'll come back to me. I think, Tim, you've covered a lot of things in this particular slide.
Yeah, sure. So one thing I would say is, as far as service providers go, I have seen kind of, I would say through my advocacy practice, when I'm in meetings with service providers, they often don't say too much. And they do have a lot of good information. And I think they often feel like, well, this is the school, it's not their place to say anything, but they can talk about the child. And we're not, when we're thinking about, I always go back to the purpose of IDEA, and we're preparing students for life after high school. And if you kind of think of it through that lens, you are going to have a lot of input. So I really encourage parents that have outside providers, maybe home in-home therapists or peer mentors, if they're coming to the meetings, ask them to talk about what they're seeing, because they have a lot of very valuable information to share.
I remembered what I was going to say now, is that some of the families that are on tonight may have also been corresponding with their districts during the shutdown. And so paper and what you have written and emails that you have exchanged are going to be extremely important, because if you wrote, my child is not logging on day after day, they're very anxious, they can't sit, what do I do? If you have been sending that and communicating that with your district, that's also going to be important as well.
Absolutely, that's a great point. So I have another slide up here. Again, this is taken from a frequently asked questions that the state put out at the end of August of this year. As to the question is, how can I help the IEP team understand how my child did during periods of hybrid? I think it has much of the same things that we're saying about sharing information, but it just again gives you an idea that the state is thinking about this and trying to provide guidance to families and to teams in terms of making these decisions about makeup services for what's been missed. Let's take a second to talk about process, and then we'll go back into a little bit more against the actual mechanics in these meetings. One of the things that is curious about the guidance that was developed around COVID compensatory services is that it does leave the door open for making decisions, not just at a team meeting, but in general. So it allows for informal calls or meetings or Zoom meetings or in-person meetings between school administrators and families to discuss the notion of COVID compensatory services. And that's fine. It doesn't necessarily have to be a full team meeting with all 8 or 9 or 10 providers sitting around the table. If you feel that that's not going to be productive, you can ask the school to do this in a more abbreviated fashion. But there are cases in which you do want everyone at the table and you want to do it through a team meeting, and parents should be able to drive that process. But the state has basically said that to school districts, you can do this however you want, as long as you can come to an agreement. You know, that's fine. And if you come to an agreement, it's got to be put into writing. You have to use a form similar to the form that we use for documenting other decision-making. We call it an N1 form or notice of proposed school district action. You know, you get these all the time. You know, usually you think of them as a cover letter to the IEP in which they explain what things were considered. They're supposed to, you know, include what things were rejected and the school said that they can't do, and provide the reasons for that. But basically, it's a document that establishes a record. Again, you know, written records being so important. So, Janine, anything to add to that?
Yeah, just to let people know, just like with your IEP, you can and should respond to the N1, particularly in this instance and in writing, if you disagree with the services.
Absolutely, right.
And so it's documenting your position and then making sure you email that or get that information to your school district. So that's what I would add.
Carol?
I was just going to say the same thing. I think
Good.
it is so incredibly important that parents are reading that, the N1, and responding.
So one of the things we should make clear is that compensatory services don't need to be put into an IEP and probably shouldn't be put into an IEP. These are services that the school district owes you for failure to do something in the past. They're not the IEP services that are necessary to provide a free and appropriate public education in the future. And so it's probably better not to think of this as an IEP amendment, but as developing a separate agreement for the provision of these services.
Good point.
So again, the state's guidance basically gave us a 5-step process. You know, first is, you know, were there services missed? Has the student regressed? And a lot of school districts, you know, warn you, want to stop there and say, oh, we haven't seen any regression. But that's not where it stops. This isn't a, you know, a situation where it does. As Janine pointed out earlier, the next question is has the student failed to make effective progress? So whether the student regressed is not as important as perhaps did they get anywhere during this period of closure. And Carol will talk to you about how we can prove that. And then the next question that the state has allowed the districts to say is, well, look, you know, we're going to provide these general education recovery supports to everyone. And, you know, the team needs to consider, is that enough? You know, do we have to make up special education services? This should be a relatively easy question to answer because it's really hard to see how in any situation, general education services can replace special education services. But the state has put this into the analysis. And then finally, when you get to that point and said, okay, yep, there were missed services, there was either a regression or a lack of effective progress, general ed's not enough, and then the team determines what compensatory services are. We're going to talk about that in some detail.
Yeah, and just to stress that it should be an individualized determination and based on that own student's expected progress. So that's really important.
Great. So at this point, I'm going to turn this over to Carol. Carol, you can just tell me when you want your slides advanced. Okay.
Okay, thanks, Tim. So I'm going to talk about how parents can prove regression or gather the data to have that conversation with the schools. Next slide, Tim, please. So special education is really a data-driven business. And when we think of getting this data, there's both school data that's out there for every child, and then there's special education data. So we're going to talk first about school data. Every child is getting an assessment at the beginning of the school year. It's usually happening in the fall, and then again in the spring, there'll be what we call baseline assessments. So I gave you here, there's a couple of examples. You have like a STAR assessment, MAPS assessments. And these are looking at your child's basic skills around reading, math. It'll break it down into different areas of math, different areas of reading. And that's going to look at, so where the child is in comparison to their peers. The second thing is your formative formative data. And that's really more of in the moment, it's more of continuous data. I think of it as when I was in school, it was like you came in and they said, we're going to have a pop-up quiz today, you know, put your books away. And you're like, ah. But so that's really what your formative data is. It's homework, participation, those kind of quizzes that are happening over and over again. And then summative data is really looking at what your child has learned throughout hopefully the year or an IEP period maybe. And it's a measurement against what was taught throughout the year. So if we think of our Common Core curriculum that every child is learning, and we're trying to find out, did they learn that information? And so we're going to know that through maybe midterm evaluations, final evaluations, report cards, progress reports can talk about that, SATs, MCAS testing. These are all things that are going to give you really good information about that. We're really looking at, so what a child has learned after the teaching has happened. Anything you all want to add to that before I move to the next slide? No? Okay, next slide, please. So this is our data around special education. And I try to kind of keep it in the same, set in the same kind of framework so you would understand it a little bit. So we think of like our baseline assessment, it's the same idea. What assessments do they do to evaluate your child to make them eligible for special education? So a few examples would be your cognitive assessments, possibly a WISC or a WIAT, speech and language, occupational therapy. These are some other ideas of what you might see in an initial evaluation or a 3-year evaluation. And then your ongoing assessments would be, you know, behavior charts, daily logs, sample work, homework. It could be quizzes again, communications, anything. We're kind of seeing how things are going over and over again throughout the process. Progress reports, because those are happening as often as report cards. You could kind of look at some of those. And then the last piece would be your child's progress. So again, progress reports, the one closest to the end of the IEP period, a child's new IEP, when you're starting to write a new IEP for the following year, we're looking, did the child make their goals over this the past year? And then 3-year reevaluations are really going to give us good data. Has the child progressed over the last few years? I do want to mention rate of progression should be considered, especially during COVID. So what that means is if we, to try to simplify it a little bit, if we have a child that maybe has a reading disability and is really slow to progress, and their rate of progression is typically maybe around 8 months of progression during a 1-year IEP term. If you're starting to see maybe 3 months, if you look back and they're only this last year and a half, they've really only progressed 3 months or 6 months, their rate of progression has went down. And so that would be you know, a data point to be thinking about when talking about compensatory services. Anything you want to add to that, Tim? No? Okay. So
I think that's good.
Okay. So I put together just a really simple goal, and I did this so that as a parent, you can try to understand how you can gather this information from your child's IEP. So this is a goal around a girl that's getting reading services, and it just says Emily is currently reading at an instructional baseline level E. So the color yellow is what I use. Is I use 3 different colors, and I'm taking it. Anyone can do this. Just get some highlighters, and I'm highlighting what the child, where they're at. So your baseline level E, this is where they are at today when the IEP was written. 95% accuracy and so forth. Your blue is how do we know that information? So your baseline assessment is telling you that. And then the green is where we're expecting the child to be at the end of the IEP period. So for this child, it would be reading at a level J, 95% accuracy. And again, the blue would show how we're going to know that information. So through formal, informal assessments, work samples, and teacher observation. Next slide, please. So if you look at the progress report and you kind of use the same idea, you take out your highlighter, you look at, you know, how they've measured the progress. So in this instance, it's a baseline assessment, teacher observation, observed progress in reading comprehension. And then we take a highlighter and look at where the child is at today. So she's reading at a level J, her accuracy is 95%, and she is comprehending 2 out of 5 questions. So she hasn't met her complete goal, but this is a way to kind of look at it and see if you divide it into 3 parts. So we look at where our child's at, where she's going, and then how we're going to know that and how we're going to measure that progress.
So one thing I might interject here is that this is great if the school district has been doing a good job in terms of filling out these reports and actually staying on the topic and reporting information. But oftentimes, I mean, first of all, during the pandemic, actually during all of last year, we all saw, and many of the families, I'm sure, saw progress reports that said we're unable to report on progress towards this objective because of the remote instruction or because of school closure. And, you know, so one of the questions is, what can you do about that? Janine, Carol, any ideas?
I look at that, that's a data point. If you cannot report that, that is data.
Mhm. Mhm.
And
So-
I've seen that, I'm going to talk about it. I've seen that so much where we can't report on progress. We haven't worked on the goal because of COVID. We don't know the current performance because of COVID, but that is data.
Mm-hmm.
Yeah, we've seen that too, and just families not even getting their progress reports as well.
Sure.
Or them being vague and not having, you know, detailed information like this.
Mm-hmm,
Right.
mm-hmm.
Right. I think one of the things you're saying in a way, Carol, is it's really kind of an absence of information from the school. So they should be paying more attention to what the parents are presenting in terms of progress, because the school lacks any information whatsoever. And I think that if you had to go to a hearing or about something like this, the fact that the family has some information and the school's acknowledging it doesn't is important. I think you're absolutely right. It could be a very decisive factor.
Mm-hmm. Yeah.
Okay. So I guess that brings us to this next slide.
Yeah. So we talked about some of this stuff earlier, Tim, in one of your other slides about, you know, how do we get data beyond the school setting? And, you know, I think of letters from pediatricians, developmental pediatricians, obviously neuropsych evaluations are great. And home logs, I love home logs. I think those can give us, you know, some really good information. If you did keep a log during COVID of, you know, what your child was doing every day, that is valuable information if you were able to kind of keep track of that. But if not, was there communication, or is there now about, you know, some school or some children have daily logs that go back and forth. And you could look at that log today and say, oh, I'm seeing, you know, behavior problems 4 days a week. I wasn't seeing this pre-pandemic. So that's good data right there. Information, again, from coaches, after school activities. This is all good information. If you have a child who was able to, you know, participate in after school activities with relative ease, and now all of a sudden you're getting called to pick your child up because they're dysregulated, that's a data point. That is saying that they're having trouble and something has changed. And so are there, you know, are there home services? I've kind of talked about this a few minutes ago, you know, getting the home providers to write letters, to come to meetings, to talk about what they see, because they're in their home, they are seeing a lot. And if they've been involved pre-pandemic, they're going to be able to talk about what the behavior was prior to the pandemic and what it looks like now. One other thing I wanted to add, thinking about to transition and kids getting ready to leave school, is another data point is how was your child, how did they react to the CDC guidelines during the past 18 months? Were they able to wear a mask outside? Were they able to social distance? You know, were they able to, when you went to the grocery store and we all had, you know, we're used to that tape on the floor that made us all stand 6 feet apart. Could they do that? Were they constantly encroaching on the person in front of them? Were they, I want to say following the arrows, although I had trouble with that too, but, you know, so this is, but it is good information, because if we think about, you know, the purpose of IDEA, I go right back to that. It's life after high school. And if you say, I couldn't take my child to the store once during the pandemic because they ripped their mask off, they wouldn't stand in line, you know, that is good information. So that is another data point I think you could bring to the team. Do you all want to add anything to any of that?
I think that was well said.
Thanks. Janine?
Oh, I thought it was very good too. And also the reminder about the services for older students is important.
So this is an example of a compensatory. So this is a family that I'm working with, and I'm going to actually invite Janine and Tim to talk about this. This is a family of a child that has a pretty significant disability, was unable to access remote learning back in the spring of 2020. And the parents had, I think, a couple of 2 or 3 meetings in the fall, asked for compensatory. The team talked about it. They didn't grant it. So the parents filed with PRS, and they denied services because of the procedure that the district had filed or had followed the procedure that says the district documented that students, IEP team met and discussed the students' need for compensatory services. So I think this is a really good example because parents often think to go to PRS to file for compensatory. So I was hoping Tim and Janine, if you all could talk a little bit about what in a case like this could be done differently and what parents need to be aware of when it comes to procedural versus substantive information.
Sure, I'll jump in. One of the things that we've given you as a handout is a chart that the Mass Advocates for Children have put together after reviewing about 60 or 70 PRS complaints over the last year or so. And it's a very compelling chart, and I really advise you to take a look at it. But what you'll find is kind of one consistent theme, unfortunately, and that is that PRS is great for enforcing procedural rights. If, for example, the school district has not had a meeting at all to discuss CCS, PRS will order them to hold a meeting. But if a meeting has been held, if the district has come close to complying with the guidance around COVID compensatory services, then PRS is going to find that they complied with the process. They are not going to substitute the judgment. So even though the district may have decided that, we're going to provide, 2 weeks of a boot camp in the summer, and that will take care of everything. And, evidence shows that it wouldn't take care of the many, many missed hours or come anywhere close to meeting the child's needs. PRS won't be able to make that kind of judgment call. And so, so what's really important is to use PRS to get your meetings, to get current compliance. And that's the other thing that we want to talk about is that, many families continue today, even though we're fully back in school, services aren't being delivered. Aides, there aren't enough paraprofessionals out there, kids aren't getting their paras. Some of the related services, speech therapy, occupational therapy, physical therapy. Nursing is a big issue because of staffing issues. All of these things are happening. And, if you've tried to work these things out with the school district, these are good things to go to PRS about, because PRS will at least require the schools to try and do some things about the current problem. Now, I'm not saying necessarily it's going to be a great solution, because, you know, if it's a nursing one-on-one nursing issue and nobody knows where you can hire a nurse, PRS isn't going to have an answer either. They're simply going to tell the district, look, you have to work with the family about developing a plan to make up for any services lost when you can finally provide those services. But I think that's kind of the distinction that I would make. You know, they're great at things that are black and white, but not able to make things. And part of it is the process, you know, with PRS, because PRS is really a paper review.
Exactly.
And in fact, you know, I should mention, I mean, many people don't understand this, but you make a complaint to the state about a school district's failure to comply with some particular element of special education law. PRS actually tells the school district to investigate itself. Now, that actually works better than you might think it does, you know, for the most part, but it still kind of indicates, again, the limitation of the process.
Yeah, no, I think it's well said. And again, it's compliance. Compliance also, as you were saying, with when you're looking now going forward in terms of your current IEP, the last accepted IEP, and in terms of the services that are listed in there. So it's important.
So should we keep moving forward? You have some good tips here, Carol, I'd like to go through.
Okay. So I put, you know, I probably could come up with a lot more, but these are a few things that I think are important. So the first one is like, don't get too bogged down with what didn't happen. And I would say this to parents, you know, if we weren't talking about COVID, I think this is something that I have seen a pattern of, you know, and it's hard. I mean, I know as a parent, it's really hard when you feel like, you know, your child's been wronged or, you know, something didn't happen that was supposed to or in a timely manner. But I can also say, you know, if I'm using the example of it took 90 days instead of 45 to evaluate, a school will sit there and talk to you about that for an hour, and then you haven't moved forward. The fact is, it still took 90 days and you haven't moved forward. So you have to really kind of take that stuff and put it on the back burner. There's a time and a place for everything. And if you're trying to move forward and get your child services, talking about what didn't happen is not going to be helpful to move forward. That's one thing. Second thing, and this is really important, especially around the kids that are going to be graduating this year. If you do not feel that your student is ready to graduate, you need to reject the graduation date through the IEP process. If you don't, then you're kind of out of luck. So a couple of things about this. If you've already, you know, if you say, oh, my child's IEP was written in September, it's too late. It's not too late. You can go back, you can change your mind, and you can amend your response to your child's IEP.
Yeah.
The other, you want to add something?
No, I was just going to say particularly, and I think we have a slide later on about that, about students that are close to age 22 and those that maybe did not get services during this time. It's really, really crucial.
It really is. Yeah, it really is. And the other thing I would say about this is if you're undecided about, you know, you're not like, I'm not really sure, they may be ready for graduation, err on the side of caution, reject the graduation date. The school will be more than happy to give your child a diploma and send them on their way. So if you change your mind, you know, you can then again amend the IEP. So err on the side of caution there. The other thing I would say for kiddos too is the one thing to be thinking about is how the child, and this is for kids that are, you know, on a more of a, I would say, a standard track of graduating in 12th grade, how they're going to feel about staying in school, if that's what you're trying to push. You have to get, you know, your kids got to be on board with this for a lot of kids. I can tell you right now, if somebody told me in, you know, November that I wasn't graduating, I would have blown my top. So, you know, your kids got to be on board too. It's one thing to just say, oh, I think they need to stay another year, but they really need to be a part of that decision. And then the third tip here is just requesting records. I mean, we kind of talked about this data. This data is available to you. You just have to request it. Every parent is entitled to their child's records. I think, Janine, doesn't MAC have a template on there? Yeah. So You can just write into the school saying, I'm requesting my child's records. It's part of the general education laws. It's, I believe, 10 school calendar days, one of the two.
Yes,
Mhm.
correct.
And they will send you your child or tell you where to pick up your child's records. And then if you're, I can't, is it free lunch or Mass Health and they're free, the records?
Well, most districts actually send them for free to almost everybody.
Most
But
of them, right.
Yeah, I mean, what the federal law says is that if your income is going to stop you from being able to access the records and it's necessary to protect special education rights, they have to provide them for free.
Okay. Okay. I think I've only seen one school charge for them, but I
Mhm.
think most of them give them for free. But
Mhm.
that's just another thing about making sure
Sure.
that you're getting that data from the school. Do you all want to add?
Well, I do want to add a couple of things, particularly about this graduation thing, because
Mm.
this year it's a particular problem. And many people don't probably realize this, and you may get caught unawares, but we have a waiver of the MCAS requirement this year. We had it last year, we have it this year. And what that means is that you may have a child who has been on an alt MCAS all their life. And, you never anticipated that they would graduate before age 22. Some school districts are in a rather unscrupulous fashion saying, oh, the MCAS is waived. You therefore have met the graduation requirements. We are ending special education. And so I just want to stress what you said about being on top of this. The
Mhm.
sooner that you start dealing with this issue, the better. You certainly want to make these points now. And you've got to go back. It's tricky. You've got to go back and look at your IEP, because
Mhm.
usually there's a place, and it's someplace right above additional information, where the school says what the graduation date is. And if that graduation date is next June, reject it. Immediately get a letter off and say, I may have accepted the IEP, but I see now there's a graduation date. My child won't be ready. My child won't meet the requirements. Say whatever you can, but reject it now and
Right.
start the process of dealing with that now.
Mhm. And the state also has some really good guidance in terms of their post-secondary materials regarding graduation, because it's not just meeting the MCAS standards or meeting the local area standards, it's also receiving FAPE, and transition is part of FAPE. So that's really important.
Right.
Mhm.
So I'll let you, Carol.
Yeah. So some of this we talked about a few minutes
Yep.
ago around, when you're seeing progress reports that states due to COVID, we were unable to work on the school, or current progress not determined because of COVID. I've seen this a lot. And again, that is a data point. It's not one you want to see, but it is a data point. The other thing is vague data, no concrete information. That's always, pre-COVID, post-COVID, that's always a red flag when you're not getting good data. Especially when you're seeing IEP goals that have really vague information. Last one is offers being made without knowing how much or where your child regressed. So I know some schools are making kind of these blanket offers to parents of, an extra week of summer school, or, an extra speech once a week. And it may be appropriate for some kids, but it's important to know what's appropriate for your child. And if I would caution parents that if you're in a meeting and they say, well, this is the offer, you don't have to make a decision right there and then. You can say, thank you, please note that in the N1, and we need to talk about it as a family, and we will be sure to get back in touch with you. And then you can really think about, is it an appropriate offer?
Yep.
Because it may be and it may not be. The other thing I would just stress is it's not, it's not going to be one-to-one. If your child missed 20 speeches, you're not probably going to get 20 speeches, but it's really about making a child whole and giving them that information that they've missed. I'll let you all add to this, whatever.
I was going to say, I think Tim's next slide might talk about this somewhat more too.
Okay.
So it's a good transition.
It is a great transition. I will, though, say one thing about what you're saying. When you get those progress reports, and we shouldn't be getting any more saying we can't measure this because of COVID, but you're still going to get progress reports that rather than refer to the nice detailed benchmark that you develop for your IEP, in which it says, Sally will learn 20 new words a term, you get this statement, Sally's making nice progress. We spent a lot of time reading, this book or that book, but it doesn't say anything about the 10 words or 20 words.
Right.
And, unfortunately, it means that you got to do some work. You've got to email back and say, you're not responding. And it's important to do that. I did bring a matter like this to the Bureau at one point. It was one of many claims, but, the hearing officer did find that the failure to give adequate progress reports impaired the parent's ability to participate in the team process and therefore was a significant violation of the school's obligation to report on progress. So I make it serious.
Absolutely.
We're running a lot close to, well, we're at 6:10 now, and we do really want to answer some questions. And I see from looking at the Q&As, there's a lot of really great questions that we should try and get to. So it's kind of hard to figure out what we can do. Let me just say this about CCS, or COVID compensatory services or compensatory services in general. They can be almost anything. And here's where you need to be really thinking about it. I mean, we've already said you got to do the hard work of getting all this information together to show how badly your child did or how they regressed or how they've failed to make progress, to make the claim. Now you have to show what they need. And given particularly the staffing crisis that we're in right now, this could be the most challenging thing. It's one thing to say, oh, this child's going to need another, extra month of school, or is going to need, another 30 sessions of speech, or is going to need more ABA. But you can't find the providers for these things. Now, again, as Carol was saying before, that doesn't make a difference. I mean, it's once you've come to the agreement that the student needs this and it's money in the bank, you put it into an agreement and it takes care of the statute of limitations problem. If it's an agreement, it's a contract now that's enforceable through contract statute of limitations. But you should be prepared to come to the table and think about these issues. And, can my child take an extra, do I really want them to be in school earlier in the day or late in the day? Do I want them to come on Saturdays? Do I want them to come during the summer? Do I want these things to happen? And think creatively about it. As we said at the very beginning, schools have got this American Recovery Plan money, and they're willing to spend it. And so if you can identify a service that's out there, tutoring, human math, or something of that nature, and you don't just think about it, but you actually pursue it. You go to Kuman and say, can I take my child? How many sessions would you recommend? How much is it per session? When can you start? And you come to the meeting with that kind of information, you're going to be much more likely to get a school district to say, oh yeah, we don't have anybody that can do math tutoring, but if you can provide that, we'll do an agreement and agree to fund 30 hours of that service. So that's tricky and that's hard. And again, this is where having someone else think about this with you and deal with you about this is important. But just realize that it's kind of an open door to be creative. In the past, before COVID, a lot of times we used compensatory services to trade off for things. I mean, if you need an evaluation right now and you're not set into a situation where you can use an independent educational evaluation right, you're past your 16 months or something, you could trade that off. You could trade it off for computer equipment or other technology, or, you just think about what might be helpful to your child. It doesn't have to be a one-on-one as to what's missed. You can deal around these issues. But I will warn you one thing, don't go out and buy services first and then come to the CCS meeting and say, pay me for these things. There's already been one hearing decision in which a hearing officer said, I'm going to apply this 10-day rule that we have in IDEA, which doesn't really apply to this kind of context, but the hearing officer thought it did. And, which essentially says that before you take your child and put them in a private school and have the school district pay for it, you have to give them 10 days notice. We tend to see this, unfortunately, get applied to almost everything. So don't go out and get tutoring without telling the district you're going to do that. But if you've got it set up and you haven't been able to come to a district, to an agreement with the district, get all the details, put it in an email to them saying, you know, we can't agree on CCS, but we think this is the way to go. We're going to go out and purchase this service. This is to give you 10 days notice of our intent to do so. And then you could be in a position to preserve it. So, Carol, Janine, what should we do at this point? What would be most helpful, do you think?
I don't know if there's other slides. You know, I think you've covered some of this. I think there was just some at the end. Regarding, yeah, the turning 22. There seems to be a number of questions that have come up through the chat.
Good point. So this slide has essentially the information from the guidance last August about specifically the problem of kids turning 22 between March 17th and December 23rd, 2020. And, you know, this was an area where the state says you've got to have meetings and you've got to do it right away, and you've got to do it before the end of December, and you've got to come up with services. But what this doesn't address for us is, unfortunately, the practical problems of the turning 22 situation. I see that there's a number of questions in the Q&A around this, and this is a problem we hear all the time. Students who are in a post 12th grade situation in a transition program where they're doing some kind of supported work or some kind of specific training, many of those opportunities fell apart totally during pandemic because businesses shut down. Others didn't want, you know, only accept the key essential workers present. So many of these opportunities for work disappeared altogether. Other things that in the transition area disappeared because of staffing issues and continue to be a problem. I don't have an immediate answer to this. If the school, if it was in your IEP that your son was to get 12 hours a week of supported work opportunities, and they didn't get 12 hours a week of supported work opportunities, that is a valid CCS claim, or if it's happening now, it's just a valid compensatory claim. And the student has the right to get that. Now, some school districts will say, well, we have to provide it before the age 22. That's utter and complete nonsense. It has no there's nothing in the law that says that. And in fact, there are cases that say just the opposite, that services can be provided post 22 to students. Now, it gets more complicated if you're talking about students who are in residential schools and whether or not those students can stay post 22 as a matter of compensatory. Part of that's a licensing issue, but so far the state has been good about granting waivers to the licensing issue. So ordinarily, you know, most of the residential schools are not set up to provide services to adults. Some of them do have adult services, but most don't. And the state has agreed to waive the requirement that students have to exit at age 22 and allow those schools to continue to provide compensatory. However, it doesn't make the school provide compensatory. And again, it needs to be funded, if it's compensatory, by your school district to make up for those missed days.
Yeah, and I was just also going to mention in terms of there were some amendments that were made right now that are in conference committee regarding supporting students turning 22 during COVID, where current amendments are asking for $10 million to be set aside regarding specifically for this age population. And I think the one thing, Tim, that you also were starting to allude to for students that may need services beyond age 22, certainly we have seen where you can negotiate also with the adult services in terms of when services are going to begin. Those things are happening. They have been happening with DDS and other adult agencies that where things can be worked out so that these services can take place.
So I see Leslie. Leslie, that must mean that you want to ask us some questions.
I'm trying to follow up on some of the turning 22 questions because there's a lot in there. The only way that a student and a family would get services past 22 is if there is a written agreement with the family and the district regarding compensatory services. People are saying, you know, I want that extra year for my child, and that's not available. It's only compensatory services that are done by written agreement past the age of 22. Is that correct?
That's correct. There, some states have amended their state laws to extend their eligibility age for students that were affected by the pandemic. There is pending legislation in Massachusetts, but it probably is not going to pass. And I think that unfortunately, some people thought just because the legislation was there, it was a reality. It is not a reality, and it probably will not be a reality. So again, it means all the more important to be negotiating these CCS deals and agreements.
Exactly.
So we've also had a lot of questions around, you know, districts really pushing that standard of regression as how they measure, and how is there a specific language? You know, we know that the family's observations and data is supposed to be valued in these contexts, but it's hard sometimes when the school is just saying this is the standard. Is there any language or guidance that would help a family, you know, make a case that it's lack of progress, it's lack of attainment of goals, you know, those kinds of things that you've referred to?
I mean, I think the slide that we were showing earlier, I think it's really important if families can bring in that information to their teams to say, this is what DESE is advising that teams do. They have to go through these 5 questions, because otherwise, as Tim said, they're going to stop on question number 1, and families wouldn't know that they have the opportunity to be able to say anything. I've sat in meetings where I've been an attorney at a meeting and had a team just continue to say no regression, no regression, and you have to just jump in there. So it's a challenge.
And the other thing is the school delaying or ignoring the complaints. So what would trigger like this statute of limitations? That we have a letter that we have shared that is saying I want a meeting, but a formal complaint would be the only thing that would start that statute of, you know, limitations.
And actually, a formal complaint, say to PRS, doesn't do that either. It must be a filing at the Bureau of Special Education to make sure that it's preserved. Now, again, you have 2 full years to do that, but there is nothing short of that. You know, there are exceptions to the statute of limitations. You know, it's essentially the rule about statute of limitations is that actions need to be brought within 2 years of when the parents knew or should have known that there was a violation. Now, it's hard to say that people didn't know that there weren't violations of the failure to provide services beginning in March of 2020. You know, we knew that. Unfortunately, it doesn't mean that you have to know that there's a law about compensatory, et cetera, et cetera. It's that you have to know when the harm starts. So get these things going. And, you know, again, if the school district is ignoring, go to PRS. PRS will issue an order that they have to meet. And you're still within two years. You know, you've got until March before these things start being clipped off. And again, they don't clip off everything. They just clip off each day as you move forward. So, you know, if you haven't had a meeting, you send the letter. If they don't respond in 10 days, go to PRS, period. And
So,
PRS will respond within 45 days and make them have a meeting.
right. So the meeting is so important because it lays out your concerns, starts the process, and moves you to hopefully resolving some of the issues. I know a lot of school districts have pushed back saying that we can't really evaluate your student because this is the first time we're seeing them this fall. Is these first 2 months now that we've had, is that enough time that they've been able to observe the student and determine where they're at? Because we haven't had a marking period yet.
You know, I find those kind of arguments to be humorous myself. You know, the fact is that there's no amount of time. You know, if the school district has some questions, they can test, they can assess. You know, we have under, you know, the regulations, 45 days in Massachusetts school days to conduct evaluations from 0 to evaluation to a team meeting. You know, so those are all kind of good markers to look at by comparison. But when they start saying things like that, that's just nonsense.
Some school districts pushed out IEP waiver forms during the remote learning time. And I know there was some guidance around that, but are any waivers that a family signed during remote learning, are they binding still? Do they affect this issue around COVID compensatory services?
So if you look at the max PRS chart, I think there's at least one waiver case in there in which PRS says, hey, you can't do that. In that case, you know, the district had stopped using the waiver form already, so it was kind of irrelevant. But I don't think that any hearing officer would enforce a waiver of that nature against a family. We haven't seen those cases yet, but I would say don't worry about those.
I don't believe that the ARA funding is available to the private Chapter 766 schools. I think it's only available to public schools. If your student is in a private school, can you get access to any kind of that funding through your school district because it is a private placement, an out-of-district placement?
Well, the public schools can use that money to encourage the schools that they contract with. I mean, there's some limitations because of the way school financing works in Massachusetts. You know, a rate is set by by a separate agency of the state with regard to how much schools pay for these things. But at the same time, the state has also been pretty generous in saying, you know, requiring school districts to have continued to make payments to the public school or private schools during the time that they were closed and not providing any services to students. So while a private school can't access that money directly, they can indirectly by telling the school district that they need to do that. This question of who's responsible for CCS during the closure is kind of an open question. The state ducked it in its analysis. They kind of said, yeah, you know, you ought to try and work it out and hopefully you'll be able to do that. But that hasn't happened. And we have seen some situations in which school districts are saying, okay, you know, we paid this much money to the Higashi School for Residential Services. The student wasn't there. The student missed it. You, Higashi, should be responsible. In my opinion, those aren't really special education claims. They're contract claims. You know, the school district can pursue Higashi all it wants for its failure to provide services during that time. Families shouldn't be caught up in it, and we shouldn't have to worry about it. Ultimately, the school district has the responsibility for making up missed services, period. Don't worry about who's going to get the money.
So there are a couple of questions regarding staffing and the school using the lack of staff to not provide the services. And we've heard some talk about, you know, can you be creative, find some outside services, and then bring those creative solutions to the table first before you contract out, and make sure that there's a written agreement that the school will fund that. It's a little bit more different when the student requires a nurse, because that's not as easily found outside of systems. And so you just need to document with the school that the student has lost services.
Yeah, unfortunately, nobody's come up with a really good answer about staffing problems. And, you know, I mean, you can certainly do things like, you know, constantly be making sure that the school district is making all reasonable efforts to recruit, that they're doing the standard things that anybody would do to try and recruit a nurse or a one-to-one para or an Orton Gillingham tutor or wherever the services is necessary. You know, there are certain websites you can go to. There are different places you can post. They can seek assistance from the state to fill vacancies. They can ask for waivers. There's a number of things that can be done. But, you know, when it comes down to it, nobody, no judge, no one in the world is going to be able to produce a nurse when there aren't nurses. And all you can do is make your record and get more hours when it's eventually done. Again, looking at the MAC list of PRS complaints, there were several ones about nursing. And PRS was really good about saying, you know, if a student didn't get a one-to-one nurse, even when they were home during COVID, the school district owes them for that. And the school district has to come up with a way to provide that compensatory service.
So I have a quick last question. A unique situation where a student, you know, during COVID was in District A and lost services and then moved to District B. And so where would they claim? Do they go back to District A?
Yeah, well, they go back to the district that didn't provide the service. And this has been pretty standard. I mean, this is pre-COVID. We've always had these kind of claims. I mean, I had a student who moved to Puerto Rico, but we still got a school district ordered to pay for services in Puerto Rico because of a violation of not delivering the IEP.
Great. So it's we have about a minute left, unless you want to add anything else. I just wanted to remind everyone who's attending that the Federation and also Mass Advocates for Children have call lines, information centers, and please, you know, reach out, ask your specific question. There's people there to answer in multiple languages so that we can help you. There was a question, Janine, whether the letter was available in different languages.
I believe it's at least in Spanish, but
Spanish.
it may have been also translated into 1 or 2 other languages.
Okay, so we'll try to push that information out on our Facebook page and the link to that. You should have received all of these materials as part of your registration. If you did not get the information, you know, just connect with us, send us an email, and we will make sure that that information goes out to you. I just want, on behalf of the Federation, I want to thank you. Tonight was a really nice practical approach that I think empowered families to move forward and to start to work with their school district to help their student just, you know, move forward. So thank you so much for joining us tonight and have a good evening.
Thank you.
Thank you.
Thank you.